It's me, Albatross, again. Okay. I'm sorry about the. I don't know. I left off on an emotional note last night because of the last part of this CPS investigation of Riverside we were reading. This poor boy who was born with this deformity or this birth defect where his bladder was on the outside of his body. It's just like these poor babies. Like, I just don't know why more people don't talk about this. I don't get it. But okay, we're gonna continue. Okay. Alright, where I left off. According to one of several media reports on this case, CPS had 18 months of reports for this boy with the birth defect, detailing harm and neglect. The SSPs decided those reports of harm were either unfounded, inconclusive, or left open, which is like no final determination. The SSP wrote in her report that no children are likely to be in immediate danger of serious harm in that household. Therefore, the children were not removed from the home. Testimony before Riverside... Wait a minute. I thought this was civil. Now it's saying criminal? Testimony before a Riverside criminal grand jury exposed the agency's failure to take decisive action to protect this child from torture, emotional harm, physical harm, and from being brutally unalived. Well, if there's no body, they can't find him. How do they know? I don't know. Anyways, the SSPs checked on the boy at least 3 times before his disappearance. Okay, this is where it's really disturbing. They admitted, the social workers admitted that they were aware of the child's hands being zip-tied behind his back, and he was dunked in cold water, and, oh my God, that he was sent to school without pants? Okay, I'm gonna try to tell myself that this boy just ran away and found a better home, but I know better. That is pure evil. I don't know what's more evil. The one doing the zip tying and the harming, or the social worker who knew it happened and said that they weren't in any immediate harm. Okay, the disappearance of this child is considered a no-body homicide. For those of you who don't know, that just basically means it's like an unaliving, an intentional unaliving without having a body, according to Riverside County District Attorney Mark Hestron. Okay, a 14-year-old girl, unalived, of a you know that rug that's out there, that's everywhere, OD in 2020. Allegedly, CPS failed to remove the child from her rug-addled mother, despite warnings from hospital staff. Really cutting it loose with the terms there. Her rug-addled mother, despite warnings. I mean, apparently she was. If this child died of a ethanol overdose, then apparently the mother was. I'm just surprised. I'm just not used to seeing the government use those kinds of terminology. Like, usually they would say, like, I don't know, a mother who struggles with substance, you know. But no, they're just going all out, saying to the drug addict. It's like, okay, all right. But I mean, listen, apparently she was. There's no excuse for any child that small to, no excuse whatsoever. I don't know. I'm not going to judge too quickly because, like, I don't believe a word CPS says. Okay. Next, according to a lawsuit before the U.S. District Court in Riverside, medical staff, in parentheses, mandatory reporting, contacted CPS to alert this newborn and the mother tested positive for, like 3 different types of rugs. But it's interesting. I'm not going to say them, but I mean, like I said, you can go look up this document pretty easily. But, like, those 3 drugs, I mean, they're all, like, prescription. So, I mean, that's what I mean. Like, they were all prescription. So, yeah, she might be rug-addled, but, like, she's getting these rugs from a doctor, not a rug dealer. So, I digress. Anyways, the child's grandmother, through an attorney, stated, as a result of their failure to act, this kid is unalived, and I pin it on them. Talking about CPS. Whew, okay. According to a news report, the SSPs, with the concurrence of their supervisor, allowed the newborn to stay with the mother and advise her to participate in a, quote, voluntary safety plan. Instead of filing a petition or seeking a court order, which is what the social worker should have done, she cut the kid loose to the mother and said, go take some rug classes. The SSPs left the newborn in the care of her, there they go again with this terminology, of her rug-addled mother. And with their supervisor's approval, the case was closed. 14 months later, the child stopped breathing. Riverside police responded to a 911 call. She was taken to the hospital where she unalived from an OD. Parents were charged with unaliving and child unaliving. Riverside County spokesperson claimed that the county could not comment on the case, but offered the following statement. Our social workers are dedicated to best practices and keeping children. See, this is what I mean. Like, no accountability whatsoever. We are saddened when a child suffers an untimely unaliving and reflective about the circumstances surrounding that unaliving. Our hearts go out to her family and loved ones. Like, no accountability, no responsibility whatsoever. Like, none. These people are unbelievable. Okay, they go into here a little bit of their methodology. I'm not going to go too deep into it. I'll just read the, like, highlighted points. Their methodology includes, develop an investigation plan. 2, conduct research. 3, consult with legal experts, advisors, and Riverside County departmental authorities. 4, conduct interviews. And I guess that's it. I mean, other than all those other little points. Okay, now we get to the part of their investigation. Here we go. Regarding the foregoing reports of the children who suffered or unalived as a result of harm or neglect, Department of Social Services and Child Services Management is prohibited from directly and authoritatively responding to the various editorials and articles. Officially, the organizations cannot provide a response due to legal constraints. Following is the statute and related codes that prohibit public information officials from answering questions from reporters or others that are specific to a client or case. Yeah, I'm not even going to read all that. That's their codes or whatever. You can pause and read it if you like. Okay. The regulation, of course, limited the amount of information available. You see, this is what I'm talking about, okay? Now listen to what they're saying. The regulation, of course, limited the amount of information available to the grand jury in its inquiries. The SSPs we spoke with either refused to answer our questions or claimed no knowledge of the cases. However, the news groups apparently had some sources willing to divulge information, and their reporting provided some insights for further analysis in this study. So basically what they're saying is no one wanted to talk to them and answer any of these questions when they were doing their investigation, but there was apparently someone who didn't mind talking to the press. That's basically what this investigation is saying. In an article published April 2022 in Press Enterprise, Riverside County Supervisor Kevin Jeffries made some very significant statements concerning the lack of transparency and poor coordination between agencies of the county. His comments were in reference to an ongoing independent investigation. His comments were in reference to those Turpin kids who were like tortured and all that. But like they said, however, due to their relevance to this study, his statements are included below in their entirety. And he says, the Board of Supervisors expressed frustration at what members said were legal barriers preventing a full accounting as to how the county protects vulnerable children and adults. Supervisor Kevin Jeffries. It is the most frustrating experience in my time I've had on the Board of Supervisors, is to be told you're responsible as an elected official to make sure all these things run smoothly and you have the right people in place. But you can't ask any questions about how they do their job or how effective they are or the problems they face. My experience in our ad hoc community and in our closed session to try to get to the root of some of the challenges we face was met with, I can't tell you that, Supervisor. I'm sorry. I can't disclose that, Supervisor. I can't tell you how it happened, Supervisor, he said. He later added, we are asking employees to accomplish a mission that is almost impossible to accomplish under current state rules and regulations, where you cannot ask another agency within the same family to help you address a need of a child. One agency can't ask another agency to help because it's violating privacy. Okay, whatever your name is, Kevin. Riverside County's experience of incidents related to child harm and child neglect and child unalivings resulted from those behaviors is not unique. Various research reports on this subject and several news articles indicate that it happens recurrently throughout the state of California and the nation. So he's saying this is not an isolated thing with Riverside. He is literally saying this is a recurrent thing throughout the whole nation. Yeah, that's what he's saying. Sorry about that. I had to pause and help my dog in the house. Okay. The SCNG reported that the Los Angeles County has had extensive studies of child unaliving cases, most notably the Gabriel Fernandez unaliving. In a 2019 audit report, the California State Auditor's Office concluded that the DPSS department unnecessarily risks the health and safety of the children in its care because it does not consistently complete child harm and neglect investigations and related safety and risk assessments on time or accurately. As a result, the department leaves some children in unsafe and harmful situations for months. In a June 2021 news conference, Orange County District Attorney Todd Spitzer said that the initial facts in the case of Santa Ana parents who were accused of stabbing and beating their 2-year-old daughter were beyond disturbing. He added, children should be surrounded by love, not violence, and it is our responsibility as a society to stand up and protect our children when their own parents have abdicated that responsibility. Okay, I agree with most of that statement. And yeah, there are a lot of parents that do abdicate that responsibility. But like I said, it's frustrating because I don't know, it feels like there's a huge lack of accountability here on the part of the social services, more so than the parents. And the reason I say that being, they put themselves in this position where their decisions rank supreme above a child's own parents, right? They are put in that position by our government. So why aren't they holding themselves to this accountability? I don't. Anyways, The SSPs we interviewed certainly echoed that sentiment in their comments and stated that they worked diligently to reflect it in their performance. However, they expressed some frustration over increasingly heavy caseloads, which sometimes hinder their ability to properly conduct their investigations, which we probe further in our interviews. In our interviews with the SSPs and the managers we spoke with, we engaged them in a conversation about certain focus areas from the 2012 to 2013 Riverside County Civil Grand Jury Report and the External Review Analysis and Process Improvement Report 2019. The reports are highly detailed and lengthy, therefore only the focus points of this study are discussed in condensed fashion, as follows. Okay. Okay. The civil grand jury made in the 2012-2013 report, they made 6 recommendations. And they are global assessment, collateral contacts, structured decision making, criminal background checks, referral alerts, and history alerts. Funny. You would think this would have already been in place, but whatever. I digress. The DPSS-CSD indicated in their responses that the grand jury's recommendations, with a few exceptions, had been implemented or would be implemented. This was confirmed during our interviews with the SSPs and managers we spoke with, along with our reading of the applicable policies and procedures in the current Child Services Division Handbook, which is extensive. Okay. And I'm going to skip that. Yeah, training caseloads. They say that a lot. The DPSS-CSD clarified the grand jury's interpretations of WIC 18994.43c, explaining that the code only applies to the California Families and Children Home Visitor Programs, and it does not refer to CPS. Interesting. So basically, this stipulation about the client caseloads, they're saying it doesn't apply to CPS. That's what I'm getting out of it. Okay, here we go. This independent review of complaints and claims identified certain categories of process issues from 2008 to 2018. The issues were placed into 5 overarching categories. For the purposes of this review, we examined the following process issues. Wrongful removal with and without a warrant of a child, which is supposed to be illegal, mind you. But they are saying wrongful removal with and without a warrant of a child. The second one is failure to remove an adequately investigate or respond to referrals. Okay, and they go into a little detail with these 2 areas. Wrongful removal of a child. According to the report, it was the most common category of claim. I repeat, in the years between 2008 and 2018, the wrongful removal of a child was the most common category of claim, which included wrongful removal with a warrant, wrongful removal without a warrant, and unclear as to with or without a warrant. These claims also included allegations that social workers violated practices, policies, or procedures. I repeat one more time for emphasis. These claims also included allegations that social workers violated practices, policies, or procedures. A warrant is an order from a juvenile court judge that orders CSD and law enforcement to carry out actions in the best interest of a child. As explained in the external report, County Council implemented a new warrant process effective January 2015, and the number of wrongful removal claims filed declined. However, apparently the new warrant policy produced unintended consequences over the next 4-year period, such as duplication of work, process inefficiencies, and lack of clarity of roles of the county council and SSPs in child removal action. Okay, and in 2019, they collaborated to correct these issues for roles and responsibilities to be clearly defined, re-education, blah, 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 make appropriate decisions to protect children, integrated training model, county council to... Okay, but yeah, like, where is the part where we focus on the kids? This is all about their stuff. Anyways, okay, and then the second most common complaint is failure to remove and to adequately investigate or respond to referrals. Yep. That's another one. Including the foster homes. Alright. Okay. Well, part 2 is already getting long. I'm going to have to pick up right here in part 3. Thank you for listening.